Thank you very much, General. I'd like to call, אני רוצה לקרוא ללורן ג'יזל, יועץ משפטי לצלב, האדום, בבקשה. Please. Did you utilize your water?
Thank you for inviting me to speak here today at the Institute for National Security Study. It's a great pleasure to be with you. Ladies and gentlemen, as we have already mentioned several times today, today's war takes place in densely populated areas, and that trend will continue in the years to come. It creates a number of specific challenges to protect the civilians against the effect of hostilities. The intermingling of fighters and civilians renders the protection of the civilians more difficult, though no less necessary or compulsory. Also, hostilities in densely populated areas are more prone to result in widespread destructions of civilian infrastructure. Syria is a current sad example of the humanitarian consequences of warfare in such an environment, but these challenges appeared in many other recent armed conflicts from Afghanistan, Iraq, Gaza, Libya, Sri Lanka, or Yemen. Today's distinguished speakers addressed many of these challenges in great depth and with a wide variety of perspectives. The short time available will allow me to tackle only a few of the challenges raised with regard to the rules on the conduct of hostilities. But even before discussing them, let me recall that while the conduct of hostilities paradigm applies only in armed conflict, it does not govern every use of force in such situation. For example, in case of civilian unrest, a rioting crowd, in a situation of armed conflict, the use of force will not be governed by the law enforcement paradigm, but it will be governed by the law enforcement paradigm and not by the paradigm of the conduct of hostility. So before relying on the conduct of hostility paradigm, a commander has to establish that those rules are the one which applies to the situation at hand. So I will first discuss the definition of fighters and civilians, then dwell on the precautions that needs to be taken to spare the civilian population, notably the question of warnings, and I will conclude by a few words on the protection of the medical mission. Let me start by recalling something which is certainly obvious for many of them. The law of the conduct of hostilities is based on a fundamental principle, the distinction between fighters and civilians. All persons who are not members of state armed forces or of organized armed group of a party to the conflicts are civilians, and as such they are protecting against attack for such time as they do not directly participate in hostilities. I will come to that in a minute. On the other hand, IHL does not prohibit direct attack against fighters, provided that the other IHL rules are respected. So that begs the question, who is a fighter? For state regular armed forces, it's relatively easy. Combatant status is regulated by domestic law through incorporation into the forces and is expressed through uniforms. But there is nothing comparable for other forces, be them irregular armed forces belonging to a state or an organized armed group belonging to a non-state party to the conflict, such as an insurgent movement. And by organized armed group, let me clear, I do not mean the non-state party to the conflict, but only its armed or military wing. We have to make the distinction. In the ICRC's view, which is shared by many military experts and states, a functional approach must be used to determine whether an individual is a fighter belonging to irregular armed forces or to an organized armed group. Such individual loses his or her protection against direct attack for the duration of the period during which he has a continuous combat function for that party to the conflict to whom he or she belongs. However, mirroring the fact that not every civil servant is a soldier, not all persons that are associated or even part of a non-state party to the conflict become legitimate targets under IHL, only those who have such a combat function. For his part, a civilian loses his or her protection against direct attack for such time and such time only as he directly participates in hostilities. That's a concept which is undefined in IHL, and that's why the ICRC issued in 2009 an interpretive guidance on that notion. I'm not going to detail because that would take me 2 hours, but in a few words, somebody is directly participating in hostilities when he made act which must result in specifically type of military harm, that there is a direct causal link between the act and the harm, and that there is a nexus between that act and the conflict. Individuals who provide only ideological or financial support to a non-state party to the conflict do not meet those criteria. Thus, they remain protected against direct attack, just as in the case of politicians or taxpayers of the belligerent state. Let's recall that even civilian workers working in a weapon factory remain civilians, and as such they are protected against direct attack. That does not mean that nothing can be done against people who support a non-state actor to the conflict when it's something else than a combat function. They certainly can be prosecuted criminally under national law. They can be interned for security reasons, depending on the threat they pose. But this is another debate. It's not the question of conduct of hostilities. For the conduct of hostilities, there is no such third population as has been suggested earlier today. It really relies on the fundamental distinction between those who are protected against direct attack and those who are not. There are certainly gray areas. I don't want to hide the difficulties. There are gray areas, but we don't think that those gray areas should be that an attempt to deal with those gray areas by creating a third category of person are helpful. On the contrary, we think that the dichotomy between those who are protected and those who are legitimate targets is the basis of IHL and must remain so. In densely populated areas, military objectives and civilian objects are as much intertwined as fighters and civilians. This requires constant care to ensure that objects that are being targeted correspond to the definition of military objective, which in our view constitutes a customary law. There are, however, differences in the understanding of the elements of that definition of military objective. For example, some argue that it is enough for an object to become a military target when it serves in one way or another to sustain the enemy's capability to fight. Such a broad reading is, in our view, not compatible with the terms used by the law. The law requires that an object makes a contribution that is effective and that it serves the military action of the enemy. Also, for the requirement that the destruction or damage to the object must offer an advantage to the attacking party. Again, some tend to conceive such advantage in broad terms. However, in the law, it narrows the advantage to be obtained from such attack to those which are definite, meaning not vague or hypothetical, that are military, that meaning not political, economical, or moral, and that exist at the time of the attack. We believe it is crucial to strictly apply the concept of military objective also in urban warfare. However, in moving front lines within the urban environment might make such assessment of what is a military objective very time sensitive. Sweeping or anticipatory classification of an object are not allowed in this regard. It needs to be at the time of the attack. Objects related to, owned by, or associated with the enemy cannot be collectively considered as a military objective. Urban areas also contain a concentration of objects which serve both a civilian and a military purpose that we usually call dual-use objects, railway lines, electricity grids. There are many others. Before starting to plan an attack against such objects, the question of whether their destruction offers in the circumstances at the time a military advantage must be carefully verified. And this leads me to the principle of precaution that we have already touched earlier today. The fact that the fighters mix in the middle of civilians is made even more difficult because they don't always wear uniforms and not even always carry arms openly, just as the example that you had mentioned, General. This reinforces the importance of the obligation to take all feasible precautions to avoid or minimize incidental civilian casualties and damage to civilian objects. According to various interpretations given by states, feasible precaution is usually understood as those which are practicable or practically possible, taking into account all the circumstances ruling at the time, including military consideration, but also humanitarian consideration. While what is feasible is thus highly contextual, it should not be misconstrued as granting a completely discretionary decision power to the commanders. Those precautions that are possible in practice are compulsory according to the law. Many military manuals stress also that commanders must obtain the best possible intelligence, including information on concentration of civilian persons and the civilian environment of possible military objective. Let me turn to warning. Warnings are a very important tool in the commander's toolbox of precautionary measures. The law requires that each party to the conflict must give effective advance warning of attack, which may affect the civilian population unless circumstances do not permit. For example, where the elements of surprise is essential to the success of an operation. Warning must be effective, and what does it mean? That must be evaluated from the perspective of the civilian population to whom the warning is addressed. It must be given in the language they understand and through a meaning they understand. They must be precise enough, giving instructions on what to do. A sign or a sound does not constitute an effective warning unless the person to whom it is addressed knows what to do when he or she see or heard the warning. The warning must also be construed so as to enable the civilian population who received the warning to take an action that will effectively protect them in view of the reality of the concerned battlefield and military operation at the time. They must reach as many people as possible among those who could be put at risk. Warning must be given in advance, not too late obviously, but also not too early, otherwise the civilian population might think that the threat has passed and come back to the place if the warning is not precise enough. So, for example, to be effective, warnings that would instruct people to leave a specific area must give sufficient time for the civilians to leave the said area in view of the size of the area, in view of the means available to leave it. And they can be appropriately given only when there is actually another area where civilians could go and face less risk, no risk or at least less risk, that is either known to the concerned civilian or that is, it's even better, that is specified in the warning. Let me stress that warnings, even effective warnings and timely ones, will not relieve the attacking party of its obligation to take all other feasible precautions to avoid incidental civilian casualties. Experience have shown, and the scenario which was showed this morning mentioned it also, that civilians being warned might remain in the area. And the reason why they remain is not relevant for the conduct of hostilities. And anyway, in practice, it will often not be known for the commander who has to take the decision to attack. In any case, the attacking party that issued the warning cannot simply, because of the warning, think that all individuals remaining in the area are legitimate targets. Assuming that a legitimate target has been identified in the area, the attacking party still has to do everything feasible to assess before the attack whether there still might be civilians, how many, and whether this might lead to excessive casualties in relation to the direct and concrete military advantage anticipated. The attacking party must also take all precautions in the choice of means and method of warfare to avoid or minimize civilian casualties. That's particularly important in densely populated areas. We have seen in recent conflicts that military operations in urban areas have seen the use of explosive weapons, which can have devastating humanitarian consequences when used in such environments. So due to their significant likelihood of indiscriminate effects, and despite the absence of an express legal prohibition for that specific type of weapons, the ICRC considered that the use of explosive weapons with a wide impact area should be avoided in densely populated areas. The question of precaution raises also the issue of the risk that one's own forces might be faced with or when, when taking precautions. And General, you mentioned that also earlier in your presentation. Usually, of course, commanders have a duty on the national law to protect their own soldiers. Such a duty has to be applied in accordance with the rule of IHL. While the obligation to take precaution is precisely limited to those which are feasible, disregarding altogether the obligation on the motive that one's own forces would face a threat would certainly not be compatible with IHL. Let me also stress that the impossibility to verify that a potential target is a military one, because this verification would create to one's own troop too much risk, does not render the attack lawful. On the opposite, if doubt remains, the person or the object must be presumed to be protected against direct attack. Let's turn to the other side. Both parties also have to take precaution to protect the civilian population under their control against the effects of attack. They must avoid locating military objectives within or near densely populated areas to the extent feasible. I do not underestimate the difficulties to do so when waging warfare in densely populated area. That difficulty was already stressed by several delegates at the diplomatic conference in 74 to 77 that led to the adoption of the additional protocol. And despite that difficulty, they included that rule, which arguably also applies in non-international armed conflict today. Party must also remove civilians under the control from the vicinity of military objective. This might lead to the displacement of civilian population, something which is normally forbidden, except precisely when it's the security of the population which is at stake. Those rules are clearly linked with the prohibition to use human shields, which is a well-established rule of IHL and actually a war crimes. So it's a very relevant topic in that situation. Let me stress, however, in that regard, that the violation of the law by one party do not relieve the other party of its obligation. IHL is not based on principle of reciprocity, at least not how the law is applied today, even if morally it has been the reason for why it started a century ago. The latest point I would like to shortly touch upon are certain particularities on the rules governing the conduct of hostilities as they relate to medical personnel, medical transports or units, which enjoy specific protection and which are found mainly in urban setting. They lose their protection from attack when they commit an act harmful to the enemy outside of their humanitarian function. Even then, however, protection of an ambulance or a hospital will cease only upon a due warning, which is not subject to the caveat unless circumstances do not permit, as for civilian objects, as we just discussed earlier. In addition, that's when it's possible, in appropriate cases, a time limit must be set after which only the protection ceases. Finally, those waging hostilities have the obligation to ensure that the wounded receive the medical assistance that they require, including enemy fighters or civilians. This includes that efforts must be undertaken to actively search for, collect, evacuate, and treat the wounded after an attack if circumstances allow, which is normally the case when the area is under control. And if circumstances do not allow for the forces to do it themselves, at least that they ensure that others may do so, whether it is health worker of the other sides, a civilian population providing first aid, humanitarian, or medical civil servants. In urban warfare, this also implies that when a checkpoint or a barricade is made in a road, those who erect such barricade think of how can the ambulance go through. It's easy. It's very often possible to totally block a road with the building on both sides, but then you completely prevent evacuations of civilians, of wounded person, be them civilians or fighters. So urban warfare does create also specific challenges in that regard. Let me conclude by underlining that I fully acknowledge that waging warfare is always a tremendously difficult and dangerous endeavor. Warfare in densely populated areas raises particular challenges with regard to the rule governing the conduct of hostilities. IHL rules allow for the possibility to take into account the particularities of the situation, sometimes by requiring, for example, to take the precautions that are feasible and to search for the wounded when circumstances permit. These rules, as I mentioned before, nevertheless do impose positive obligations that all parties to the conflict have to respect. The principles that they embody are time-tested and must be upheld in current conflict. Thank you for your attention.